He has 10 minutes to proceed.
Thank you.
Much obliged. Your Honors, at the beginning of this hearing, we made you a promise. We promised you that the evidence will show on March 1st, 2020, that search was lawful and evidence obtained as a result of the search was obtained lawfully. We promised that the evidence will support that Miss Eltra Parker had no reasonable expectation of a privileged conversation with her lawyer in the jail cell with a guard present. We promised we will show that the evidence found in her car was obtained lawfully and handled carefully by authorized persons. And we have done that. Your Honor, we know that the burden was on us, and we met our burden. But, Your Honors, the standard of proof in this evidentiary hearing is the preponderance of our evidence, which means we have to show that there is a more than 50% chance that these evidences that we want to introduce in the main trial were obtained and maintained legally. Your Honors, we do not deny that there are some irregularities and technicalities in question here. And we agree that technicalities can be argued in a trial where the standard of proof is beyond reasonable doubt. But in this trial, while balancing the probabilities, technicalities cannot be given that much weight without any hard proof of illegality. Because we will show you that the mere irregularities has in no way compromised the reliability and probative value of the evidence. Now, Your Honors, let's look at the first issue. The search was a reasonable search upon reasonable suspicion. Officer Strait explained the reasons, and we also submit Officer Strait explained the reasons. The defendant admits to making the statement, "I don't do drugs anymore." We asked Officer Strait why didn't he get the defendant a lawyer when the defendant said, "Do I need a lawyer? How can I get one now?" The officer said he didn't interpret it as a communication of a necessity of a lawyer. And the law says only person who were charged with any offense has a right to a lawyer, and the defendant was not charged with any offense at that moment. So the officer did not violate any of her fundamental right. Your Honors, all of these are undisputed. Now, the only disputed fact is whether Officer Strait informed her about her rights or not. Let's look what the evidence says. We have put Officer Strait in the witness box, and he under oath has testified that she informed the defendant about her rights. Now, on the other hand, they have produced the defendant and another former police officer who was fired for drinking on duty. Now, you have heard from Officer Bent that she is not 100% sure that she listened to the whole conversation. And she also did not confirm. She said she doesn't recall Officer Strait informing the defendant. And Your Honor, we must understand that her department says she was fired due to drinking on duty. So it is normal that she might not recall everything. Therefore, as far as her testimony is concerned, there is no probative value in her testimony. He himself is not 100% sure. Now let's get back to the defendant. The defendant claimed that the Officer Strait did not inform her about her rights. Therefore, we have two testimonies, one of the arresting officer and one of the defendant. Now, let me tell you why Officer Strait's testimony should be given greater weight than that of the defendant. The defendant, in her own testimony, said that she was studying late the night before, and in the morning she went to her job in the delivery run. She admitted that her eyes were bloodshot due to this hectic routine. There was a visible physical sign of tiredness. Your Honors, temporary memory loss can be caused by sleep deprivation and tiredness. And in her cross-examination, she didn't want to cooperate and took shelter of her written statement. She said that she doesn't know whether her lawyer was present with her when Officer Momo told them about unavailability of a private room. This is not an information she cannot possibly know. So it is highly possible that the defendant does not exactly remember the incidents of that day. On the other hand, there is no suggestion why the court would not believe what Senior Officer Strait testified under oath. Therefore, Your Honors, if we balance these two testimonies, you can see that clearly there's a more than 50% possibility that Officer Strait informed the defendant about her rights, and therefore the arrest was legal and subsequent statements made by the defendant are obtained legally. And the probative value of the statement as a tendency evidence is substantial in a drug-related case, as it goes towards establishing the defendant's connection with drug-related issues. Therefore, we request this court to admit into evidence the statement made by the defendant voluntarily that "I don't do drugs anymore." Your Honors, Now let's look at the second issue. It is a fact that when the defendant's lawyer came to the police station, no private room was available. It is also a fact that the defendant had a choice and her lawyer was informed, and the defendant's lawyer said that the defendant and the defendant's lawyer wanted to meet immediately in a jail cell. It was their choice. Now, the question was regarding the prediction when a room might be available. As you saw, even the defense witness Ima Yenta testified herself that it's not possible to know how much time an interview might take. They may say that a room in fact became available within 15 minutes. But your honors, what does it prove? What if the desk surgeon said, okay, wait 15 minutes, you will have a private room, and then the room was unavailable for an hour? There's no time limit and no way to know how much time it might need. So the desk sergeant didn't want to make her any promise that the desk sergeant couldn't keep. But it is a fact that the defendant knew, as per department policy, that a police officer would be present during her conversation with the lawyer, and she agreed to it. Your honors, the defendant complained that Officer Momo didn't tell them about that their right to privilege will be waived, but her lawyer was with her. Officer Momo is not bound to give her legal suggestions. Officer Momo told her that a guard was going to be present. It was her lawyer's duty to tell her that the attorney-client privilege will be waived in this time. Again, you have seen the defendant in her own written statement and in this court today described the contents of her privileged conversation. She said, I told my lawyer I don't do drugs. Your honor, the defendant claims that Officer Momo's testimony should not be admitted into evidence because of the privileged nature of the conversation. But when the defendant discussed the contents of the privileged conversation in her own written statement as well as in this court today, she herself waived that right to privilege. Therefore, it is not a question of whether privilege should be broken. It's just the question whether Ms. Eltra Parker is saying the truth or Officer Momo is saying the truth. And that is a question to be decided on the main trial. Therefore, we request the court to admit Officer Momo's testimony about the conversation with the defendant's lawyer into the main trial. Your honors, regarding the third issue, we understand that there are some irregularities. We understand that there is a missing signature and 2 details in the chain of custody form. But that doesn't mean the law was broken. Your honor, the law requires these details in order to know where the evidence was, who handled it, and on what purpose. And we have brought 2 witnesses today for that purpose. Regarding the accountability of the evidence in the checkpoint, you heard Officer Strait confirm that it was handled properly. Regarding the evidence when it was in the police station and in the lab, you heard Abhi Sutro confirm that it was handled properly. Your honors, the irregularities that the defendant's lawyer tried to show are in the chain of custody form. But your honor, the chain of custody form is not the evidence in question today. The evidence in question is the white powder, which was later found out to be 750 grams of pure cocaine. Your honors, it is unfortunate that there are some irregularities which give rise to some technically valid points. But it will be more unfortunate for the society and the competing public interest if a potential prosecution was stopped due to some honest mistake and irregularities of technical details done by the police. We further submit that the police officers connected has acted in good faith and lacks necessary scientific knowledge and mental acumen to actually tamper with the evidence. As we asked all of them, they didn't know the defendant prior to that incident. Your honors, and then comes the probative value of the evidence. Your honor, this evidence on its probative value alone should be admitted. This is the most vital piece of evidence in a drug-related charge. The public has a greater interest in having these crimes prosecuted than some mere irregularities, which arguably did not compromise the reliability or the probative value of the evidence when put on a balance of probabilities. And therefore, we submit to the court that the evidence seized from the defendant's car, which later was found out to be 750 grams of pure cocaine, be admitted as an evidence for the purpose of the main trial. Finally, Your Honor, we understand defense's frustration, but you need to understand that we are not saying that the defendant is guilty. We're just saying, please do not exclude these vital evidences based on some mere suggestions, where we have shown you that there is a more than 50% possibility that these evidences were obtained legally. The society, the public has an interest. And please let these evidences in. Let's see what the jury has to say about this. We at least owe that much to the society. With this, I'd like to conclude. Thank you, Your Honors.
May it please the court. Your Honor, Police officers do many things like checking traffic point, saving people's lives, saving criminals, but in no way they can go beyond the law, obtain evidence illegally, and make someone arrest. And this is the exact thing happened to my client, Miss Alpha Parker, Your Honor. Your Honor, on 1st March 2020, my client was on a delivery run. Then she was stopped by a police officer. Police officer straight inspected her identification and license. After done with inspection, he started searching the car by ignoring my client's necessity for a lawyer twice. Rights like right to remain silent, right to have an advocate. Not getting her constitutional rights ensured, she was arrested with the possession of drug with intent to sell. Your Honor, the prosecution told you a story that has missing pieces. Your Honor, you have heard from the prosecution witness, Officer Strait. Officer Strait clearly admitted that my client was not free to leave, and he did not ensure those rights from the moment she was not free to leave. Now let's look at the law. What the law say? Section 148B clearly says that a person who is not free to leave by a police officer, from that moment, the police officer must inform those rights, right to have an advocate, right to remain silent, to the person who is not free to live by him. But Officer Stray, Officer Stray did not do that. He clearly ignored the law, disobeyed the law, Your Honor. And on top of that, my client asked him twice for an advocate. For the first time, do I need an advocate? How can I get one? For the second time, I already asked you for an advocate. You did not give me one. Both Article 2 and 3 of Jalchano Constitution clearly ensures my clients to have a right to have an advocate, Your Honor. Your Honor, Mr. Strait clearly admitted that there was no photograph taken of the alleged evidence, no description, no details notes, no condition, no unique marking on the found evidence. Now let's see what the law says about that. The law, section 745.25a, clearly states that to establish the accuracy of the procedure of chain of custody, it begins at the crime scene. And there are some requirements that needed to be fulfilled to comply with the law. But they did not follow the law, Your Honor. You have also heard from Mr. Strait that he never put his initials at the crime scene at first place, Your Honor. Now, Your Honor, you have also heard from the prosecution witness, Officer Momo. Officer Momo is a police officer who is aware of laws and rules and regulations of Jalton Police Station. In his sworn statement, he said that the desk supervisor did not check the room. He simply believed and told my client advocate that there was no room available. He was unsure about the room, but the desk supervisor clearly stated to him the first availability of the room would be about 4 hours, but he never told that how long they would have to wait for a room. That's not it, Your Honor. Officer Momo knows the laws, knows the regulations. He clearly admitted that after knowing all the laws and regulations, he did not give my client warning about her presence for security that might waive the attorney-client privileges. Your Honor, Article 3 of the Jaltan Constitution clearly ensures the privacy between attorney and advocate. Officer Momo clearly admitted that neither he was instructed nor did he tell my client that her presence for security could waive my client's attorney-client privileges. Your Honor. Your Honor, you have also heard from the prosecution witness Abhishutro. Abhishutro admitted how he failed to mention time and failed to notice the missing badge number of Jima grade. But Section 745.25 of Jalchani Criminal Code C4 clearly states that the chain of custody form shall be identified by the time, date, and purpose as well as badge number and signature. Abhishutro clearly admitted that it was his responsibility and duty by following the law, but he did not follow the law, Your Honor. Mr. Strait admitted that he admitted in his testimony that 5 put the alleged white powder in evidence bag. But what you see from Mr. Abhishutro clearly admitted that the alleged powder was not in evidence container from the moment Strait brought it to him. And on top of that, Mr. Abhishutro did not show any concern to protect the condition of the found evidence. Your Honor, what the law says about it. Section 745.25C1 clearly requires that evidence shall not be handled in a manner that will alter the condition of the evidence. Section 745.25B1 clearly states that as an evidence custodian, Mr. Sutro must be able to testify to the court as to the condition of the found evidence, Your Honor. Mr. Abhi Sutro took 1 month just to send the found evidence from the custody to the laboratory, and there is no reasonable explanation for it. He just simply said it was not his duty. And after 1 month, all on a sudden, it was become his duty, Your Honor. He clearly admitted that Officer 5's sign was missing and his sign was important, but Officer 5 repeatedly ignored to sign it. And when the officers repeatedly ignored to sign it, he ignored the law, he disobeyed the law, Your Honor. Your Honor, you also heard from the defense witness, Eltra Parker. Eltra Parker clearly admitted that how she was not free to leave from the moment Officer Strait detained her. She asked for twice for the lawyer, but Officer Strait never ensured those rights. She was also interrogated and frisk searched during the whole search, Your Honor. She could not move. We have also heard from Officer Bent and also client myself, Eltra Parker, how they could not see what exactly was going on during the search. Officer Bent never claimed that he did hear the 100% of the entire conversation, but he don't recall that Officer Strait ever informing those rights to my client. And Officer Strait recognized the presence, and he admitted in the cross-examination, he recognized the presence before what he claimed as informing my client's rights to her. Officer 5 also spent at least 5 minutes to close the trunk. He also heard from the defense witness, Imayanta, how he clearly stated that he asked Officer Momo to check the availability of the room, but Officer Momo did not check it. He simply believed the district supervisor who did not check the reservation lock system, Your Honor. Now, Your Honor, prosecution argued this. Those are some irregularity that you can simply ignore. Your Honor, law asked those police officers to comply with the law. Nothing less, nothing more. But what did the police officer do? They deliberately disregard the law. Your Honor, deliberate the disregard of law is not just mere irregularity, it's illegality. Your Honor, if the police are get away with violating these laws deliberately and justifying their acts as a mere irregularity, in future they will not think twice to break the law, and they will simply justify their act as mere irregularity, Your Honor. Your Honor, prosecution also argued that it was for the public interest to violating the laws, what they claimed as mere irregularity. But Your Honor, violating someone's rights, constitutional rights deliberately, and claimed it is mere irregularity for the public interest is not also against public interest. It gross human violation of law, human's right, Your Honor. Now, Your Honor, when someone's violate the law deliberately, it does not limit it to 10%, 20%, 30%, or 50%. When someone breaks the law deliberately, it's the clear violation of law, Your Honor. Now, Your Honor, the prosecution has the burden to prove beyond the probabilities that they ensure my client's right to have advocate, right to remain silent. They have also burden to prove that they ensure my client's right to have attorney-client privileges. They have also burden to prove that they maintained the chain of custody form lawfully. And what did you see? They failed to prove that they ensure my client's right to have attorney and right to remain silent. They have failed to ensure my client's right to have attorney-client privileges. They have also failed to prove that they maintain the chain of custody form lawfully, Your Honor. That's why defense respectfully asks you to exclude any statement that made by my client, Ms. Eltra Parker, after she requested for a lawyer twice. Any statement made by my client with her advocate in the jail interview room, which was overheard by the jail officer. All evidence seized from the vehicle as the chain of custody form has not been followed by law, has been broken, and procedure for the collection, transport, storage, and the use of the evidence have not been followed. Your Honor, the defense rests, Your Honor. Thank you.